Namaste everyone, my name is Pranav, and in this video I am going to talk about American realism. So, American realism starts with the Path of Law by Oliver Wendell Holmes. So, more than a century has passed since Holmes published the Path of Law, which assisted in the provisions of a theoretical basis for American realism. Holmes, whose long career included 30 years as a member of Supreme Court, stressed that the essence of the realist contribution to jurisprudence was to be found on the careful examination and verification of factual data. Concepts incapable of verification has to be scrapped. The jurist should be guided by what a contemporary of Holmes referred to as the humility of the experimental scientist, who wastes no time in worrying about the absence of ultimate. In Holmes' early writings, such as The Path of Law, there is emphasis on the need to identify problems and to investigate them by keeping one's observation uncontaminated by irrelevance. The application of cynical assets should remove extraneous factors, allowing the true form and proportions of problems to emerge. By studying the real operations of law, one would discover the facts which constituted the law. The quasi-scientific approaches involved a deliberate exclusion from the pattern of study of every word of moral significance. It is not surprising to note that the Holmes rejected the muddled metaphysics of the concept of natural law. This was not to suggest that society's moral standards were of no consequence. They were, however, rarely significant for an analysis of operational matters indeed. Holmes suggested that it might be advantageous for the jurist if he were to use only words which could carry legal ideas uncolored by matters outside the law. Holmes illustrated that the importance of dissolving extraneous irrelevance by reference to the notion of legal duty. We have filled the word duty with a content drawn from morality. But when we wash away from the phrase legal duty its moral overtones, we are left with the duty viewed in terms of consequences for those who breaks the law. It is what the law does that gives duty its real meaning and significance. The law of contract provides further examples of confusion engendered by the use of moral phraseology. The concept of irrefragable undertakings, with its high-sounding overtones of moral purpose, should be washed away from any study of principles of contract as known to businessmen. Remove the irrelevancies and discover the realities of the contractual relationship. There is the guidance to be given to those who seek to discover the meaning of law. Holmes considered it necessary to expose as a fallacy which has seriously affected investigations of the law the notion that the only force at work in the development of the law is logic. On the contrary, Holmes propounded that the life of the law has not been logic but experience. In a very broad sense, he argues that it may be true that the law is partly the result of some kind of logical development, but the danger is in a confusion among jurists related to the logical format of a judicial decision and the inarticulate, unconscious attitude of judges as to the relative worth and significance of competing claims. The language of logic which may be used to provide the wrappings of a judicial decision may mask the very root and nerve of unconscious determinants of legal judgments. To understand the precise reason behind the judgment requires, in Holmes' colorful language, the use of an asset, of an investigation which will eat away expressive formalities and the confusions of logic with legal principles, exposing at the heart of the problem a shifting array of preferences and values often unacknowledged. In the common law, Holmes repeats and elaborates his injunctions to jurists to discount the part supposedly played by logical reasoning in the court's process of adjudication. The rules by which men should be governed may owe something to formal modes of logical expression, but this must not be exaggerated. The role played by perceived necessities of time, prevalent political ideas, intuitions concerning public policy, shared prejudices cannot be overemphasized in considering the basis of law. Indeed, law may be seen as embodiment of a nation's long development. It cannot be interpreted merely in terms of logic. Hence, it is important that lawyers and judges be well acquainted with the historical and social context of the law they administer. To be a master of law, one must master the branches of knowledge that lie next to it. Anthropology, history should not be neglected by the jurist. Since in order to know what is, we must know what it has been and what it tends to become. Holmes stated clearly that he what he understood by the law. In his celebrated epigrammatic definitions, which became one of the starting points of American functional jurisprudence, he notes the prophecies of what the courts will do in fact and nothing more pretentious are what I mean by the law. This is an application of the doctrine of washing away with this cynical acid and the so-called logical certainties and the moral essence of the law. Concentrate upon the law of action. The data produced will lend themselves to an interpretation of law as reality. It has been objected repeatedly that Holmes' observation is simply incorrect. Cohen, in his analysis of definition in law, suggests that the real test of definition is whether it is useful or useless. The words of a definition carry their own problems of ambiguity. What courts do is a phrase heavy with a variety of meanings. Does it equal does it have equal application to all types of court? The magistrates court as well as the Supreme Court. Is there a significant distinction between what courts do and what they say? Given the fact that many jurists and lawyers tend to perceive most judicial behavior as verbal, it may be that the real value of Holmes' definition is in its power to draw attention to operations, to the functionings of the court. It is arguable, however, whether or not the definition advances our understanding of the basis of law. Now, Goodhart criticized Holmes' formulation by suggesting that law is what courts do can be no more satisfactory to the jurist than their statement. Medicine is what the doctors gives you. In an interesting extension of his argument concerning the perception of essential features of law, Holmes suggested that if one wants to know the real law and nothing else, one ought to consider it from the point of view of the bad man who cares only for the material consequences which such knowledge enables him to predict. Do not take into account the point of view of the good man, who may find reasons for his conduct in the vaguer sanctions of conscience. The madman cares nothing for axioms or deductions. He wants to know that what the High Court or Supreme Court are likely to do in fact. I am much of his mind, declares Holmes. It is the consequence of the mode of operations of the courts which is of importance. This constitutes, in reality, the law. The events which follow on, say failure to register a registrable land charge under the Transfer of Property Act, or the pickpocket's placing his hand into an empty pocket, intent to stealing as interpreted by the IPC, constitute parts of the law. Although Holmes draws attention to the importance of consequences of court's decision, he is emphatic in his belief that the making of laws is the business not the courts, but of the legislative bodies within the communities. He proclaims the urgency of recognizing the principle that the people have the right to make through their elected representatives whatever legislation they feel to be necessary, given the needs of the community. Further, he reminds judges of their important duty of weighing considerations of social advantage. The training of lawyers ought to lead them, and judges habitually to consider more definitely and explicitly the advantages to society of the rules they lay down. The workings of the legislature and the courts should not be seen in isolation from the societies from which they spring and from which alone they derive their significance. To view the law in its true relationship, clearly and free from linguistic and moral overtones which distort the picture, forms the basis of the advice which Holmes offers to jurists who seeks to understand the reality of legal process. The common law is not a brooding omnipresence in the sky. India is not subject to some mystic overlaw that is bound to obey. A rational study of law in action is possible and necessary. In investigating the work of the court, one must keep in mind William James' insistence that adherence to the philosophy of pragmatism involved looking toward last things, fruits, consequences, factual analysis of data from which cynical acid has taken away layers of prejudice and invisible preconceptions is the key to the methodology requiring by jurists in their attempts to understand the path of the law. It would be a mistake, however, to imagine that Holmes rejected the need for legal theory. The philosophy of pragmatism to which he adhered is itself a product of compiled process of complicated thinking and applying principles to an interpretation of data. Holmes believed that we have too little theory in the law, rather than too much. Read the works of great German jurists and see how much more the world is governed today by Kant than by Napoleon Bonaparte. The path of law demands from those who seek to explore it a knowledge of legal theory, an awareness of historical development, and the continuous observation and analysis of practical activities of the court. Now, with this comes Gray into the picture. Now, Gray's outline of nature of law is a sparse, systematic account of law in the real world. Concepts are no more than human artifacts, and the mode of investigation which will enrich jurisprudence requires, according to his approach, a reduction of the problems to be examined to the essence of the evidence, which is the basis of our beliefs. Gray cites with approval of the principle attributed to early empiricist William of Ockham. Entities should not be multiplied beyond necessity. Law will yield up the essence of its nature and sources through an examination of what is, and the realist jurisprudence requires as a basis of its methodology an investigation only of those legal phenomena which will explain our experiences in the world. With this, American realism has came to an end, and in the end, I will try to sum up Cardozo's principles, Cardozo's contribution to our knowledge also. So Cardozo's contribution to our knowledge of the judicial process may be said to rest on his having emphasized the social nature of the law and his belief that the judicial process cannot be interpreted as though it were an isolate a thing in itself. Law is nothing if not a means to an end, and the judicial process must respond continuously to that end if it is to be flourished. With this, the American realism has given path to Rawls, Nozick, and pragmatism, American critical studies, primary social goods, formalism, and objectivism. With this, I would like to conclude my session on American realism. Thank you.